Good evening to you, and greetings to those who are connected by distance in whatever time zone and at whatever place you are. I'm Michael Schneider, the founding partner of the Lalive, one of the founding partners of the Lalive law firm, and now one of its senior counsel. We are working in partnership this lecture, the series of lectures with the Graduate Institute, and with Professor Douglas, we have agreed that I would start the evening by giving some background to the Lalive Lecture and its objectives. The concept of the Lalive Lecture emerged from the close link between the Graduate Institute of International and Development Studies and the Lalive firm, and in particular the two brothers, Dr. Jean-Flavien Lalive and Professor Pierre Lalive. It has as a basic aspect the work objectives of the two institutions or partners, especially from the perspective of the interfaces between several aspects of law and practice. The interface between public international law and private international law, the interface between research and teaching on the one hand, and the practice of international relations and international law on the other, and the interface between those who develop a case and those who decide it. The interface of the link between academia and practice is obvious in the institute, and I need not emphasize the academic reputation of the institute, but I will mention the close link of the institute with the practice of international law and international relations. I mention the executive programs, the network of distinguished fellows, the relations with alumni and alumnae, which have a very broad range of practice, and the many practical events, one going on tonight in parallel about an international dispute or international conflict and mediation of it. On the other side of the partnership, you have two distinguished lawyers that have the sort of an incarnation of this combination of practice with research and analysis, teaching, and writing about it. And they showed a particular interest in the interface between public international and private international law. One of them is Dr. Jean-Flavien Lalive, known as one of the great practitioners in international arbitration, but he also had a major role in the support for refugees with UNRWA in Beirut and during the Second World War, with human rights, and as Secretary General of the International Commission of Jurists, the first Secretary of the International Court of Justice, and lecturing at The Hague and other places. And as a practicing lawyer with a very broad range from independence of Algeria to the Dalai Lama, from the Amen oil case and similar cases to the opera. His brother, Pierre Lalive, is well known at this institute. He was professor and dean at the law faculty of the Geneva University, and here he introduced in the curriculum of the institute lectures and seminars on private international law and international commercial transactions. He is an emblematic figure in international relations, combining teaching and the research of the law with the practice as counsel and international arbitration. Both of them graduated from the institute and kept the link with it. And we, the lawyers in the firm that keep this name, we treasure this tradition of the link with the institute and the relationship between law and practice. We do that in the way we practice the law and the cases we defend, in legal writings and teachings which many of the members of the firm conduct, and the support for legal publications, including the Crises, and finally, the support for young lawyers and their training in organizing and having trainees in the firm, and from the MIDS and other programs, and I see some of them in the room here. From the start of these lectures, 16 years ago, the lectures emphasized the interface between public and private international law. The first lecturer was the then president of the International Court of Justice, Dame Rosalind Higgins, and the subject she taught about was the International Court of Justice and some private international law thoughts. And this was followed by many other lectures, distinguished practitioners, distinguished academicians, and the lectures can be found in the Exit Review. They're all published there. Now, this link between practice and research, public international law and private international law, is well represented by our speaker tonight and the subject she has chosen. The subject, International Adjudication and Global Crises, The Devil in the Detail, by Catherine Amirfar, and you will hear more about it by Professor Douglas.
Well, good evening, everyone. It's a great pleasure to introduce our lecturer this evening. The problem I have, though, is that my introduction may just take a little bit longer than her lecture itself, because Catherine's done just about everything that can be done in the field of public international law and arbitration. And so far as I know, she's not contemplating retirement anytime soon. Now, many of you know Catherine from as the immediate past president of the American Society of International Law. Others would have worked with her as a partner at Debevoise Plimpton in New York, where she co-heads the PIL team and the arbitration team. But did you know that Catherine also worked for the US Department of State, currently serves on its advisory committee on international law, also serves on the Council of Foreign Relations, as well as contributes to the American Law Institute's work on its restatements of foreign relations law and commercial arbitration. Some of you will know Catherine as a member of the governing board of ICA, but did you know that she's also currently representing victims of a massacre in Liberia in a claim under the Alien Tort Statute? Some of you may have dealt with Catherine as a member of the Court of Arbitration of SIAC in Singapore, but did you know that she's also the deputy co-chair of the high-level panel of legal experts on media freedom? Now, I could go on and on and on and on like this in a similar vein, but the message I really want to convey is that our lecturer this evening has not spent her career in a single silo of practice. So she's uniquely qualified to draw the links between different areas of the law, both public and private, and domestic and international. And that's, of course, the whole raison d'etre of the Lalive Lecture. Now, as one would expect, the professional directories have lavish praise on Catherine. So the Chamber's Global Edition of 2022 noted that she, and I quote, "must be the best lawyer in the world for arbitration." Now, we all know that the directories exaggerate things a little bit from time to time. If they claim that she was the second best lawyer, I'd perhaps be able to accept that, but no, not the best. So anyway, we can argue about that over drinks a bit later. Now, the title of Catherine's lecture this evening, as has already been said, is International Adjudication and Global Crises, the Devil in the Details. And I guess the wonderful thing about the world we live in is that before she begins, we can't really predict which of the global crises that she has in mind. But we'll soon find out. So without further delay, could you please join me in welcoming Catherine Amirfar.
Thank you so much for that overly kind introduction. I wish I recognized the person that was described, but I'm sure someone like that exists somewhere. I can't tell you what a privilege and honor it is to be here with you. I'm very honored to deliver this year's Lalive Lecture. I want to give thanks to Professor Douglas, to Michael Schneider for being here today, as well as to Professor Joost Pauwelen and Matthias Scherer for their kind invitation, and of course to Lalive and the Geneva Institute for hosting this event. Since its institution, this event has promoted interesting, important, and evergreen dialogue on the interface between private and public international law, and it is really a privilege to be here and with you today. Especially on such a beautiful day, I congratulate you for spending it indoors with me this evening. So you've heard of my topic. I want to start with a basic premise. As Judge Simma wrote in his commentary on the UN Charter, and I'll quote, "The principle of the peaceful settlement of disputes occupies a pivotal position within the world order whose hallmark is the ban on force and coercion." International adjudication, I think we can agree, has long played a critical role in advancing this principle. History is replete with examples where two parties resolved a dispute by referring the matter to an international court or tribunal, and the increasingly cluttered docket of the International Court of Justice and myriad international investment arbitrations today are a testament to the continuing vibrancy of formal dispute resolution. In at least some instances, the decision to turn to international adjudication avoided a war. In a very real sense, international law succeeds where headlines are not made. At the same time, many of the pressing challenges facing the international community, global and regional crises that threaten peace and security, present a somewhat uneasy fit with what you might call the traditional mode of international adjudication. A global crisis, almost by definition, is broader than a single dispute that can be easily broken down into a specific legal question. Rather, as we know, crises are often multi-headed, involving a combination of political, legal, and economic conflicts. In an increasingly interconnected world, crisis scenarios may also involve a multitude of both state and non-state participants and stakeholders. And there's the additional complication that in many instances where the political stakes are high, as they often are in a regional or global crisis, the parties do not agree to submit it to international adjudication. And this means that often we leave the rather well-trodden pathway of successful dispute resolution through mutually agreed submission to international adjudication for murkier ground, that is, where one party attempts to compel adjudication with another party through already existing grants of jurisdiction to international courts and tribunals. Of course, barring acceptance of the ICJ's compulsory jurisdiction by the involved states, the jurisdictional purview of international courts and tribunals are limited. But as a consequence, a particular court or tribunal often can encompass only specific aspects of a much broader global or regional crisis. Indeed, certain international fora may not be available to states at all, but rather may only be invoked by individuals or non-state actors. Thus, in any given proceeding, the legal question or questions submitted for resolution in the context of crisis, I think, necessarily fail to capture the totality of the overarching conflict between the states. As a result of what I'll call this disaggregation, that is the inherent mismatch, if you will, between the jurisdiction of the relevant forum for international adjudication and the broader issues underpinning an interstate crisis, the outcome of any single adjudication is unlikely to provide a full framework for resolution of the crisis itself. These dynamics make the prospect of peaceful resolution of a crisis through adjudication in these circumstances far more difficult. However, in my view, these complications do not sever the important relationship between adjudication and the promotion of peaceful resolution of conflicts. But I do think they make that relationship more nuanced. Where the role of international adjudication in promoting peace and security cannot be one of pure dispute resolution in the traditional sense of methodically resolving a unitary dispute that drives a crisis. This point gives rise to three potential critiques of the utility of international adjudication in the context of global crises, related to first, its efficacy, second, its legitimacy, and third, its desirability. In our time together today, I'd like to investigate each of these critiques, or questions in turn, to explore what they reveal about the promise and the limits of international adjudication vis-a-vis global crises. The efficacy critique asks, given the reality I've just presented, is international adjudication actually effective in resolving broader global or regional crises? The second critique of legitimacy asks, can recourse to international fora of specialized or limited jurisdiction in the context of a broader dispute undermine the legitimacy of those institutions or the international system writ large, and in so doing, exacerbate rather than ameliorate the status quo with respect to promoting peace? The third critique poses the question of desirability. Even where available and legitimate, is recourse to international adjudication necessarily desirable from the perspective of promoting peace and security? I believe, and I hope you'll take from today's lecture, that carefully considering each of these critiques elucidates the point that while international adjudication is no panacea for resolving global crises, it nevertheless plays an essential role in promoting peaceful relations between states. So with that, I turn to the first, perhaps most basic question. Is recourse to international adjudication actually an effective tool in the context of global or regional crises? That in turn, of course, begs the question, how do we determine whether such an adjudication is, quote, or unquote, successful? There are many examples, of course, of international adjudication directly resolving a crisis between parties when those parties specifically agree to adjudicate the dispute. Many tales have been told of the arbitration commissions established by the United States and Great Britain, first under the Jay Treaty in 1794, and the Alabama Arbitration Tribunal established in 1871 to 72, paving the way for lasting peace between them after the Revolutionary War and the U.S. Civil War. The 1977 Beagle Channel arbitration between Chile and Argentina awarded Chile sovereignty over several small islands at the southern tip of South America, with significant implications for shipping between the Atlantic and Pacific Oceans. The Taba arbitration, agreed between Israel and Egypt, marked the first time Israel and an Arab government achieved pacific settlement of an international dispute. The ICJ has likewise famously resolved territorial disputes submitted to it by special agreement, including between Belgium and the Netherlands and Burkina Faso and Mali. These are just a few examples. Collectively, in this room, we could think of many more. But it stands to reason that effectiveness must encompass more than just the relatively straightforward examples of peaceful resolution where the parties agree to submit the main point of contention to adjudication. So what about the harder question? Is international adjudication effective absent such agreement? And in the context of global and regional crises, when the conflict cannot easily be boiled down to a specific legal question? I submit the answer is yes, but there's nuance to that. That is, the devil is in the details. And so I'd like to test the premise with three scenarios. First, where the underlying dispute persists even after international adjudication comes into the picture. Second, where international adjudication is unable to provide a complete remedy to a multifaceted crisis. And third, where the crisis at hand gives rise to armed hostilities. So to my first scenario, can international adjudication be considered effective when even after a decision, the underlying dispute remains contentious or ongoing, even for decades? One example is the disagreement between Colombia and Nicaragua over small island states and other features in the Caribbean. The ICJ has been seized of this question since 2001, when Nicaragua filed its application instituting proceedings. Some 20 years later, even after a judgment rendered in 2012, the crisis arguably persists. In late 2013, just before Colombia's withdrawal from the ICJ's jurisdiction became effective, Nicaragua filed additional applications instituting proceedings before the ICJ alleging violations of its sovereign rights and seeking further delimitation. The ICJ rendered its judgment in one of these proceedings last spring. The second remains under deliberation. The situation, the vagaries of iPad. This situation has remained extremely contentious throughout, with accusations of unlawful conduct from both sides and repeated clashes between the two countries' coast guards. Similar observations apply to long-standing tensions between Malaysia and Singapore over maritime boundaries and activities in the straits separating the two countries. This issue has led to multiple separate proceedings for international courts since 2002, including the ICJ and including ITLOS. In the years that follow, tensions have ebbed and flowed between the parties, reaching a high point in late 2018 as both parties claimed extended and overlapping port limits. While a bilateral summit in March 2019 helped to de-escalate that particular dispute, the situation remains contentious, 20 years and counting since being submitted to adjudication. There is surely here in these two examples grounds for an efficacy critique of international adjudication. The criticism of justice delayed is justice denied resonates in these circumstances. But it would be a mistake to regard the persistence of these crises as a failure of international adjudication to support peace building. To the contrary, the respective states have kept their dispute primarily in the legal realm. While the legal proceedings remain pending, Malaysia and Singapore, for example, have shown a willingness to engage on these issues before international courts and tribunals, while also simultaneously engaging in bilateral negotiations. And this happens frequently. With respect to Colombia and Nicaragua, hours after the court's decision to uphold jurisdiction in two subsequent cases, Colombia declared that it will, quote, not keep appearing before the ICJ, end quote. Nevertheless, Colombia ultimately continued to participate in the proceedings. Last spring, Colombian government representatives announced that they were, quote, satisfied, end quote, with the court's ruling on the merits. And of course, the crisis did not proceed to the battlefield or result in economic or other coercive measures between the states. I'm cognizant of the challenges of proving a negative, that, for example, but for the pending legal proceedings, the disputes would have escalated to a full-blown conflict. But even accounting for that uncertainty, these remain potent examples in support of efficacy. Efficacy when even the underlying crisis has not been resolved for decades. Simple fact is that the engagement in legal fora arguably deterred resort to coercive force. Now to my second scenario. Can international adjudication be considered effective if it cannot offer a universal resolution to a regional or global crisis? Again, I say a cautious yes. International adjudication can create what I'll refer to as a leveling of respective sovereign power in the sense of forcing states to meet on equal terms before a court or tribunal, engaging in those fora to articulate legal positions, and most importantly, providing a forum for engagement, negotiation, particularly where domestic political pressures make direct diplomacy untenable. This is so even when the adjudication itself does not result in a victory for the claimant state in the traditional sense. This is so even where the adjudication exercise can be characterized as disaggregated, meaning there's often no single forum in which an international crisis can be taken for all the related embedded issues. An example is the Gulf regional crisis that arose when Saudi Arabia, the UAE, Bahrain, and Egypt imposed a series of coordinated measures taken against Qatar starting in 2017. I must preface this discussion with one disclaimer. I and my colleagues at Debevoise had the privilege of serving as legal counsel to Qatar during this crisis, and I must say that the views I express today are solely my own. The measures imposed by Saudi Arabia, the UAE, Bahrain, and Egypt themselves were extraordinary, both in their scope and the speed with which they were imposed, literally overnight during the month of Ramadan on June 5th, 2017. The four states closed their airspace, seaports, land borders to Qatar, effectively rendering Qatar a small peninsula in the Persian Gulf whose only land borders with Saudi Arabia inaccessible. The four states expelled all Qataris within their borders, granting them only 14 days to leave the country and preventing Qataris from entering or passing through their borders. At the same time, these states required their own nationals to leave Qatar or face severe penalties. These measures had an immediate and severe humanitarian impact, including on thousands of mixed nationality families who found themselves on opposite sides of a closed border, facing a separation of indeterminate length. The four states also blocked Qatari media outlets, notably Al Jazeera, from operating in their countries and criminalized with severe penalties any statement or act by an individual or entity that could be construed as, quote, expressions of sympathy, end quote, for Qatar. In order to lift the measures, the imposing states demanded complete capitulation in the form of what was publicly reported as the 13 demands, a series of broad-ranging political demands related to Qatar's internal and external policies, including closing down Al Jazeera and requiring Qatar to cede its decision-making power with respect to its relationship with third states. As a country of less than 3 million residents, and to give you a sense, roughly 7% of the size of its neighbor, Saudi Arabia alone, careful watchers of the region expected Qatar to capitulate in a matter of weeks. Instead, it went on for over 3 years. In those years, there were absolutely no communication channels, formal or informal, between Qatar and the 4 states, which had cut off all diplomatic ties. The political and economic pressure can only be fairly characterized as extreme. Since Qatar could not access the outside world via its borders or any ports, and did not at the time have its own independent airspace. But Qatar did not capitulate. Instead, it turned to legal fora to seek redress under international law. Importantly, there was no single international forum that could adjudicate all of the legal issues emanating from the crisis, and there were many. However, that did not mean there was no role for international adjudication, as different aspects of the crisis were subject to binding and non-binding adjudication. Ultimately, the Gulf crisis translated into at least 14 international proceedings initiated by Qatar globally, encompassing state-to-state claims, as well as by on behalf of private entities impacted by the crisis. The state-to-state claims included a racial discrimination dispute before the ICJ under the Convention on the Elimination of All Forms of Racial Discrimination, or CERD, a civil aviation dispute brought before the Council of the International Civil Aviation Organization, which led to 2 appeals to the ICJ, and claims before multiple human rights bodies within the UN system, including the first ever conciliation proceedings brought under the auspices of the Committee of Experts charged with compliance under CERD. And in addition, in what represented a merging of the public and private facets of the crisis, Qatar Airways, the national airway of Qatar, brought investment arbitration claims against the UAE, Saudi Arabia, Bahrain, and Egypt, challenging those states' measures related to aviation, including revocation of its license to operate in those states and closing their airspace and airports to the company. Likewise, Qatari companies Al Jazeera and beIN Sports brought separate claims under investment arbitration treaties. So robust. These various proceedings went on for years, including during which there were instances involving the public threat of military force. At one point in mid-2018, there were even public reports of Saudi Arabia soliciting project bids from companies to dig a canal along the international border with Qatar and fill it with nuclear waste, seeking to turn Qatar into an unapproachable island. To date, none of these cases has gone to completion with a judgment on the merits. Some remain suspended, and the racial discrimination case under CERD was dismissed by the ICJ at the preliminary objection stage in an 11-6 decision that reasoned that measures ostensibly taken on the basis of nationality were outside the scope of the treaty. But irrespective of the outcome of any one of these proceedings or their seemingly disaggregated nature, they created multiple channels for communication among the parties about respective rights, using the lexicon of international law. The 5 states' participation in the adjudicative process itself drove the parties to engage, albeit through intermediaries and legal fora, but engage they did. That engagement created leverage and ultimately an effective alternative to the exercise of coercive power. As a result, in early 2021, the parties publicly reported on a deal that suspended cases and helped restore peaceful relations in the region with restoration of diplomatic ties between the states. The slate of proceedings arising from the Gulf also highlights the private dimension of international adjudication during crises. I've already touched upon the cases brought by Al Jazeera, Qatar Airways, and beIN Sports, just to name a few, in the aftermath, but suffice it to say that some of the largest claims for compensation related to the crisis arose in that private claim context. the relationship between international adjudication brought by private actors and peace building is arguably less direct. But these adjudications, too, can play affirmative and often pivotal roles in promoting peaceful resolutions between states. Proceedings brought by private actors can provide a forum for resolution of thorny issues underlying these disputes, such as commercial issues that are potentially a little less politicized or adversarial than direct state-to-state proceeding. They may also provide a forum for dispute resolution where there's simply none available at the state-to-state level. And they're often the type of proceedings in which the most robust compensation claims can be asserted, and especially in the investment treaty context, have enforcement mechanisms in the form of seizure of commercial assets under the New York Convention framework, for example, that have the most teeth. And finally, in terms of creating leverage, such private claims can play an outsized role in bringing recalcitrant state parties to the negotiating table. So with respect to this second scenario, effectiveness can be measured by an exercise of leveling, if you will, the playing field, whereby seeking to adjudicate international legal rights before multiple neutral fora, states can facilitate crossing even seemingly insurmountable political divides to communicate and to promote ultimately peaceful relations. This brings me to my third scenario. Can international adjudication be considered effective even where it has not prevented recourse to full-scale armed conflict? Here, in my view, we have an example of failure, particularly in circumstances when the aggressor state remains committed to acting in defiance of international opprobrium. The war in Ukraine, tragically now entering its second year, of course remains at the forefront of all of our minds here, and it unfortunately illustrates, in my view, the limits of what international adjudication can accomplish in this scenario. Following Russia's 2014 invasion and annexation of the Crimean Peninsula, Ukraine brought claims before multiple international fora, including European Court of Human Rights, an UNCLOS Annex 7 tribunal, and in 2017, the ICJ. This slate of proceedings did not prevent Russia's continued aggression any more than earlier proceedings brought by Georgia. Rather, as we all know, in 2022, Russia resumed its armed hostilities against Ukraine, this time with a full-scale invasion that has resulted in deaths of more than 8,000 civilians and the displacement of over 14 million. In response, Ukraine again availed itself of the adjudicatory fora available to it, including commencing proceedings before the ICJ under the Genocide Convention, and succeeding in obtaining an indication of provisional measures from the court only 3 weeks after the invasion. Yet Russia acted and continues to act in flagrant disregard of this decision. To put it plainly, if you look at the myriad proceedings against it, brought first by Georgia, then by Ukraine, the use of international adjudication has been ineffective in preventing Russia's aggression towards its neighbors. I want to be clear. This does not mean that these proceedings are fruitless. The proceedings arising out of both the Crimea annexation and the war in Ukraine demonstrate how adjudication can advance important goals beyond preventing or even ending the central conflict, including establishing legal accountability for Russia's action, redress and voice for victims, the recognition and condemnation of the international community, and the preservation and presentation of evidence. We can also see the private dimension at play in the context of Ukraine. Following Russia's invasion and annexation in Crimea, Ukrainian individuals and investors in the region instituted claims before investor state tribunals and human rights bodies, such as the European Court of Human Rights. While Ukraine is not a party to these proceedings, they have led to the adjudication of critical questions related to the legality under international law of Russia's conduct. For instance, investor state tribunals were faced with the question of including whether Crimea could be considered Russian territory from 2014 onwards. In this context, although again not a party, Ukraine was able to submit a non-disputing party submission urging the tribunal to take into account Russia's de facto control of Crimea. Just last month, one of these tribunals awarded approximately $5 billion in damages to the Ukrainian state-owned company, Naftogaz. Another case brought last month involved claims by Ukrainian companies against Russia based on Russia's current actions in the Donbass and appears to seek damage of over $400 million. Again here, while the road is not without challenges, private parties may be able to get more traction from these proceedings notwithstanding Russia's lack of participation, thanks to the robust architecture for enforcement of investment awards. So I do not question that there is utility. My point is that only absent that any desire on the part of Russia to cooperate in the proceedings as a means of dispute settlement, international adjudication faces significant limitations in terms of constituting an effective tool for the establishment of peace and security in this situation. Importantly, though, adjudication can be effective in the wake of armed conflict, where it can help lay the groundwork for peace and reconciliation in the future by providing a measure of justice in the present. As Martin Luther King famously said, there can be no justice without peace, and there can be no peace without justice. Though there are important caveats here as well, in that the affected parties must decide to participate. The specialized institutions that emerged following the Eritrean-Ethiopian War are instructive. Between 1998 and 2000, Eritrea and Ethiopia engaged in a 2-year-long war over a territorial dispute that resulted in over 70,000 deaths. In 2000, the parties signed the Algiers Agreement, which ended active hostilities between the two states and established 2 adjudicatory bodies to address the remaining issues. The Eritrea-Ethiopia Claims Commission was tasked with resolving all claims for loss, damage, or injury resulting from the conflict, and the Boundary Commission was tasked with delimiting and demarcating the boundary of the disputed territory. In the years that followed, relations between the states remained strained, and the underlying border conflict remained volatile. But the situation did not devolve back into full-scale, sustained armed conflict. Instead, both states continued to participate in the work of these commissions, which provided a forum for peaceful and continued engagement, and ultimately accepted their final verdicts. In 2018, the two states signed a peace deal, restoring diplomatic relations between them and hopefully signaling a more lasting regional peace. So in short, for purposes of efficacy, while the disaggregated nature of international adjudication undoubtedly constrains its ability to provide a complete answer for resolution of all dimensions of a particular global dispute, this feature of the system does not render it ineffective in promoting peaceful relations between states. To the contrary, by setting out underlying dispute in legal terms in the lexicon of law and legality rather than saber-rattling, international adjudications can engender solutions arising from the same cloth. By narrowing the disputed issues, they can remove thorny barriers to resolution. By calling the state parties before them to articulate legal positions, international courts and tribunals provide a neutral forum for engagement and negotiation, particularly where the domestic political pressures are otherwise. And importantly, states can participate from the starting premise of sovereign equality. Before the law, states stand equal regardless of the respective economic or military power they wield, that is, regardless of a state's power to coerce. At the same time, international adjudication faces significant challenges in situations of armed conflict, especially where one state determines that the benefit of war exceeds its profound costs, including from the international consequences of non-participation in adjudication. I turn now to the second critique, which is centered on the questions of legitimacy that arise when individual aspects of a broader dispute are submitted for adjudication by one party. I start with a point on institutional legitimacy. As I noted at the outset, the specialized or limited jurisdiction of many courts and tribunals means that the legal questions submitted will frequently only encompass one aspect of the larger global crisis. In practice, however, it can be extremely difficult to disentangle a particular legal question from the full context in which it arises. This often gives rise to attacks on the legitimacy of the court, tribunal, even the very process of international adjudication. For one example, the nature of China's objections to the UNCLOS Annex 7 tribunal in the arbitration brought by the Philippines regarding the parties' respective rights in the South China Sea are telling. As you know, China refused to accept or participate in those proceedings, but the terms of China's objections and reaction went beyond simply jurisdictional objections. In a white paper responding to the institution of the arbitration, China alleged that, and I'll quote, "The unilateral initiation by the Philippines of the arbitration constitutes an abuse of compulsory procedures provided in the convention and a grave challenge to the solemnity of the dispute settlement mechanism under the convention," end quote. China's statement following the tribunal's award further claimed the proceeding had been initiated, and I quote, out of bad faith, as it aims not to resolve the relevant disputes between China and the Philippines, or to maintain peace and stability in the South China Sea, but to deny China's territorial sovereignty and maritime rights and interests in the South China Sea. China went on to object, and again I'll quote, fully aware that territorial issues are not subject to UNCLOS, and that maritime delimitation disputes have been excluded from the UNCLOS compulsory dispute settlement procedures by China's 2006 declaration, the Philippines deliberately packaged the relevant disputes as mere issues concerning the interpretation or application of UNCLOS, end quote. When the tribunal rendered its ruling in 2016, China's Ministry of Foreign Affairs immediately issued a statement declaring that, quote, the award is null and void and has no binding force. China neither accepts it or recognizes it. China's challenge to the legitimacy of the decision was rejected by other members of the international community, and many states, including the United States, United Kingdom, Canada, and Japan, publicly called on China to comply. Russia took a similar approach in response to investor-state claims brought by Ukrainian investors under the Ukraine-Russia bid following its annexation of Crimea. While these cases substantively centered on investment claims brought by private parties, they also raised critical considerations relevant to the border dispute, most centrally around effective control over Crimea. Russia initially refused to participate. Instead, it submitted letters to the Permanent Court of Arbitration declaring that, quote, it is manifest that such claims cannot be considered, end quote, by the arbitral tribunal under the bid because the property in question in Crimea, quote, forms an integral part of the territory of the Russian Federation and cannot be regulated by that treaty. Russia went on to say that it does not recognize the jurisdiction of an international tribunal at the Permanent Court of Arbitration in settlement of the above-mentioned claims. Despite Russia's non-participation, several of the investment tribunals proceeded to rulings on jurisdiction and later on the merits of the claims. Russia then commenced set-aside proceedings in Swiss and French courts with respect to several Crimea-related awards, claiming, among others, that because the dispute related to the status of the Crimean Peninsula, it was not arbitrable. Russia also repeatedly challenged the legitimacy of the ICJ proceedings brought in response to its acts against its neighbors. When Georgia instituted proceedings in the ICJ under the CERD, Russia responded by accusing the proceedings having a, quote, artificial character, end quote, and sought to characterize the claims as illegitimate, arguing, quote, Georgia only decided to have recourse to methods providing for the judicial settlement of disputes after an unlawful use of force and after it had become obvious to Georgia that it would not be able to regain control over South Ossetia by such an illegal use of military force. When Ukraine brought claims under the Genocide Convention, Russia refused to participate, instead arguing in a letter to the court that the ICJ lacked jurisdiction, stressing, nowhere in the convention may one find any reference to the use of force between states or recognition of states, and to read them into the convention by implication would be to substantially amend and distort the object and purpose of the convention, end quote. It argued that, quote, this distortion is what Ukraine's submissions are aiming at, end quote. Now, it seems to me that there are two different elements of these types of responses, and it's worth taking a moment to disentangle them because I think they take us to quite different places. The first is the somewhat traditional focus on overreach, institutional overreach. The concern here is that international courts and tribunals can undermine their legitimacy if they're perceived to be acting outside their jurisdiction and mandate, or in other words, outside the scope of what participating states have consented to put to adjudication. And this is undoubtedly a real concern because it in turn undermines the ability of those institutions to remain active and important fora for peacekeeping. Speaking at this lecture several years ago, Professor Campbell McLaughlin spoke about the, quote, assault on international adjudication, in which he detailed a number of high-profile recent examples of withdrawal from international adjudicatory processes. I mentioned earlier Colombia's withdrawal from the ICJ's compulsory jurisdiction, and the United States also famously did so following the court's decision in military and paramilitary activities. Yet one should resist overcorrecting in response to this concern. Even if reasonable minds could disagree about whether or to what extent the examples I've described involved overreach, Ultimately, questions of legitimacy rest not with recalcitrant or disappointed participants to the proceedings themselves, but in whether the international community of states as a whole views the institution as having exceeded its authority. By and large, this aspect of the legitimacy critique has not prevented international courts and tribunals from aiding in the promotion of peaceful relations. However, the statements that I just referenced also illustrate something quite different about the points China and Russia were making, which leads me to my second point. What is interesting about their critique, which I think can still be fairly characterized as a legitimacy critique, is that they went beyond complaints about excess of powers or jurisdictional limits and accused the very act of instituting proceedings as abusive or in bad faith. And this criticism was grounded in the sense that the dispute submitted for adjudication was not the, quote, real dispute, but rather a convenient repackaging in an attempt to adjudicate the dispute without explicit consent. In other words, this type of critique treats recourse to international courts and tribunals of specialized jurisdiction in the context of a broader political crisis as inherently suspicious, as a means for the litigant states to advance their own interests and political objectives rather than attempt to resolve their differences, and one which inflames rather than diffuses tensions between states. At its most extreme, this critique is sometimes termed lawfare and paints the use of adjudication in relation to global crises as illegitimate. I want to pause for a moment to unpack this concept of lawfare, a word that seems to be thrown around with greater and greater frequency without a lot of thought or, I think, rigor to its meaning. Many scholars trace the modern use of this term to a 2001 paper by U.S. Air Force Major Charles Dunlap, Jr., who defined lawfare as, quote, the strategy of using or misusing law as a substitute for traditional military means to achieve a war-fighting objective, end quote. While this was presented at the time as an ideologically neutral concept, it's taken on a pejorative connotation in subsequent use to refer to the weaponization of law. According to this framing, lawfare represents the idea that, quote, law is but a continuation of politics by other means, end quote, and thus permits the use and abuse of international law to further state interests. While accusations of lawfare arise in several different contexts in international law, I'm focused here on the charge as it relates to international adjudication. In my view, attempts to dismiss the legitimacy of international adjudications by accusing states of engaging in lawfare can be destabilizing in the extreme. The idea that a state availing itself of adjudication can be derided as weaponizing law outside its generally agreed parameters is antithetical to the promotion of the rule of law, the UN Charter, and the obligation of peaceful dispute settlement. The fact that litigation is inherently adversarial, that states may be compelled to submit to jurisdiction of international bodies, does not mean that invoking their jurisdiction is akin to escalation. Rather, these basic features are what make adjudication effective in de-escalating the threat of armed conflict. It can provide a forum for peaceful resolutions when other mechanisms are presently unavailable. Moreover, in international adjudication, I submit that the notion of asymmetric warfare does not really apply. States engage before legal fora from a standpoint of sovereign equality. This means the adjudication can provide a critical counterbalance in situations where there's a clear power disparity from a political, economic, or military standpoint. This counterweight serves to protect the founding premise and promise that right makes right, not might makes right. And this is not to suggest that states can't use litigation strategically. Of course they can. But making use of the available fora is not lawfare in the pejorative sense. The fact that available forums are frequently limited, specialized, sometimes overlapping, is a feature, not a bug, of the international system. It reflects the will of the large majority of states, of whom only 73, well under half, currently recognize the ICJ's compulsory jurisdiction to hear any dispute arising between states. Thus, the legitimacy of a state's recourse to adjudication, in my view, cannot be called into question due to making use of the system as designed. And I'll end by saying that international law brings with its important limiting principles to combat the weaponization of law. The fidelity of international institutions to the rule of law guards against attempts to weaponize those institutions, the duty of those institutions to uphold the limits of the jurisdictional authority granted to them by virtue of consent to maintain their own legitimacy protects against potential overreach, the procedural barriers of jurisdiction and admissibility and the substantive requirements of their underlying claim prevent frivolous or abusive proceedings. Again, the system as designed. I'll turn now briefly to the third critique, which asks whether seeking to resolve broader political disputes within the international courts or tribunals is desirable, given the myriad complications I've just laid out. The answer to this question is, again, a favorite among lawyers. It depends. And what I mean by that is that whether international adjudication is desirable as a means of promoting peaceful resolution depends on what other means, frankly, are available. Where there's political will and a desire from both states for cooperation to bring about peace through diplomatic channels, adjudication may not always improve those efforts. In fact, it may complicate those efforts. But somewhat paradoxically, these circumstances, where there's already a basic level of cooperation negotiation, may also make adjudication more desirable, in no small part because, as we've seen, it is these circumstances that international adjudication tends to be most effective. Even when political and diplomatic channels are open, adjudication can serve as an important complement to keep parties engaged in the process and even open up new channels of communication. The Malaysia-Singapore example I mentioned earlier is a good example. Of course, when adjudication is one of several options, its benefits must be weighed against potential downsides, including potentially lengthy, costly proceedings and contributing to the entrenchment of the parties' positions in comparison to the upsides or other options. And here again, we must distinguish international adjudication based on specific consent of the parties from adjudication over objection. Where other means of resolution are available, the former clearly has less downside than the latter. Of course, when diplomatic channels break down or are simply unavailable from the outset, international adjudication can force the parties to come to the table and provide a means to resolve disputes, as I've just gone through. One example that I want to share with you is the example of Ethiopia, where it speaks to other goals than just the dispute resolution itself. And these other goals can include accountability, creating leverage for negotiations, increasing international visibility of the conflict, and reinvigorating engagement or momentum. That example is the ongoing conflict in Ethiopia, which has not received a relatively high level of attention from the international community. Some have even referred to it as the world's forgotten conflict. This is despite the fact that in August 2022, the Director General of the World Health Organization referred to the conflict and its impacts as the, quote, worst humanitarian and man-made disasters on earth, end quote. The Ethiopian government's ethnic cleansing campaign against the Tigrayan people has resulted in the deaths of over 500,000 people. Here, diplomatic and political channels have thus far been unavailing, with regional experts pointing to the Tigrayan people's limited access to and political capital within the international political or diplomatic fora. I and my colleagues at Debevoise, in partnership with the Legal Action Worldwide and the Pan-Africa Lawyers Union, brought a case before the African Human Rights Commission on Human and People's Rights on behalf of the Tigrayan people seeking accountability for Ethiopia's human rights abuses against them. Beyond the legal relief that the Commission can offer, another benefit of the case is its ability to increase visibility of the conflict, to generate that legal and political leverage for peaceful discussions and peaceful resolution. To sum up, a global or regional crisis is often more than a single dispute. It's multifaceted and resists a unitary solution in a unitary legal forum. Nevertheless, measured against the overarching goal of the maintenance of peace and security, international adjudication, even with its limitations, can play a critical role. But the nature of the role inevitably varies depending on the nature of the crisis and, importantly, the will to engage of the parties involved. What the efficacy, legitimacy, and desirability critiques reveal is that international adjudication may be most precarious precisely when it is most important, when other modes of engagement are unavailable, and even the possibility of adjudication itself rests on the ability of one state to bring proceedings over another's objection. Thank you very much for your kind attention and your patience this evening on a beautiful day. I look forward to engaging with you on any questions.
Thank you very much, Catherine. I was about to say that was a real tour de force, but maybe that's not the most appropriate way to start the lecture. It is, though, a very robust answer to the criticism we often hear as international lawyers that when the going gets tough, in other words, when the dispute involves the essential interests of states, the international system somehow breaks down each time. Of course, that's not true. The criticism is based upon often an unfair comparison about what might happen in the national legal system. But as we've heard tonight, when the going gets tough, there are many avenues available. It's not going to be a single, uniform, comprehensive, neat and quick solution to a dispute, but there are many different channels that can be pursued. And ultimately, these channels, if pursued, can be effective. And I was reminded when listening to you, Catherine, that the story that the lawyers who acted for Nicaragua against the United States, and some of us had the privilege of working with them, they're often asked, you can imagine, what was the point of that case? The United States didn't formally recognize the judgment, they withdrew from the jurisdiction of the ICJ afterwards, so what was the point of all that? And the answer they give is that, well, that judgment emboldened some people in Congress in the United States to stop the funding of the conflict, because it actually turned the course of the conflict. Anyway, enough from me. Questions? Right. We've covered just about, well, Catherine's covered just about every single issue, international dispute resolution, so I doubt there can't be any questions at all. Maybe I have some online. Yes? Okay.
Thank you very much, Catherine, for that wonderful lecture. I had one question in which I'd like your reflections. One of the things that you spoke about is really about the sort of increase in international adjudication that we see, and it's sort of the premise for the things that you have been talking about, and that's undoubtedly the case. What seems not to be the case, though, is the increase or an increased appetite for states to include clauses in treaties which require them to use adjudication. And so, you look at the list of multilateral treaties deposited with the Secretary General, and actually today there are very few that include a compromissory clause that either permits or allows states to have recourse to the ICJ. And I wonder, or even to international arbitration. And I wonder how one ought to think about this sort of almost schizophrenia. So on the one hand, the docket of the court, as you say, is bursting, and we have many fora now where states are litigating. But on the other hand, when states kind of get together and to think about dispute resolution mechanisms, they don't include today recourse to international adjudication in those treaties.
Thank you, Dapo. Excellent question. And I tend to think that it's not necessarily inconsistent. And the way that you can reconcile them is if we think about where the proliferations actually occurred. The proliferation has been in very specialized, and frankly, the more technical the issue, it seems the more willing states are willing to, or technical or commercial, willing to actually submit to binding adjudication. When you get to the more general principles, there appears to be less of an appetite for a court of general jurisdiction. So if you dovetail the proliferation of specialized courts and tribunals, I think sitting here today it's over 30 by last count, and you dovetail that with the ICJ's general jurisdiction, and what we see is over the years a steady decline in consent to general jurisdiction. I think states are sending a pretty clear signal that they want specialized courts to be there but only on clear terms of consent. Now, of course, the consent can be manifest in the compromissory clause, of course, but I think what we're seeing is a dynamic of a requirement of more specific consent. So I'll give you an example. If you look at the Malaysia-Singapore bilaterals that I mentioned that have been ongoing, Singapore said something very interesting when it committed to the bilateral negotiations. Its MFA issued a statement in which Singapore said, we don't think maritime delimitation disputes should go to courts and tribunals on a general basis. We, as Singapore, prefer a system where we commit as a state to negotiation in good faith. We commit as a state to, if those negotiations do not prevail, do not actually win the day and take us to peace, we commit to finding a binding, and they said binding arbitration or dispute resolution mechanism, as long as we get to tailor it to this specific dispute and take it forward, and we'll abide by it. I'm paraphrasing, obviously, but that was the general message. It was a very interesting message to send out into the world at the time when they're obviously enmeshed in bilaterals and thinking very seriously about the maritime delimitation issues that have been plaguing them for 2 decades. And I think that's indicative of the sense that the consent needs to be quite specific around the dispute. So we have this amazing track record on special agreements, compliance with special agreements where there consent to dispute resolution. That is robust. I submit we also have a pretty good track record for specialized tribunals where states say this, for example, in the ITLOS context, obviously China is an exception to this, in the ITLOS context, the rates of compliance in that context tend to be still pretty high. So I think what we're seeing is an evolution in thinking about compulsory mechanisms of dispute resolution and what state consent needs to look like, especially tailored to disputes. The other example that came to mind is if you think about the Paris Agreement, for example, there you can well imagine that dispute resolution might have been top of mind, perhaps politically unpopular, but top of mind. And notably, what is in the Paris Agreement is the commitment, not even the annex itself, but a commitment to take the additional step of coming to agreement on a conciliation annex. Not arbitration, conciliation. I think it also gives us a recent sense of a large community of states for these very intractable global types of issues, which are the kinds of crises that I have in mind in underpinning this lecture. They want some room to run, if you will. They want to be able to bring in some political negotiation, other levers. They want to design a bespoke mechanism if it's going to be binding on them. So I think that it's not necessarily contradictory, but I think these are exactly the types of issues that we as a community need to parse to think about resilience and effectiveness of the mechanisms. The other thing that's been very much on my mind is since the post-war order, if we think about international adjudication, I think we rightly do about peace building, maintenance of peace and security. That was really an impetus for the post-war regime. But I wonder sometimes, have we moved beyond that as a goal, as a central goal? Are there other goals for international adjudication having to do with protection of the rights of future generations, if we think about the context of the issues the ICJ will deal with in the advisory opinion in the climate change context? So it appears that there's an evolution, and that's another thing, another aspect for our community that I find very interesting about where we are in this stage, in this story of international adjudication is, are the goals more diverse now? Are they evolving? Is this something that we need to revisit on a very basic level when it comes to efficacy, desirability, and legitimacy?
Well, thank you very much. Who's going to dare to ask another question after that? After that response? Yes.
Laurence will.
Yeah, thanks, Catherine. To continue the discussion on the climate change, conciliation, adjudication, what we see now is that there are, in fact, 3 requests for advisory opinions by 3 international courts. So what is your viewpoint about this new role of courts at the international level? Is it something that states like, or is it something that it's more for other actors of the international scene? how to use the advisory function of courts and tribunals?
Excellent question. And of course, we sat on that lovely panel together at ASIL speaking about advisory opinions. I do have to start with a disclaimer in which I am representing the Commission of Small Island States in the request for an advisory opinion related to climate change before ITLOS. So I just wanted to make that clear that I'm there as counsel. In my view, advisory opinions are having a moment, and it's a beautiful moment. It is really difficult to take a look at the extraordinary level of consensus in the UN General Assembly around the Vanuatu Initiative. I think we had 130 plus co-sponsors. It was not even voted. It went by acclamation as a referral, I believe, which is historic and first time. And what we have is this appetite from this incredible, significant cadre of states saying, we at this stage want legal clarification. I contrast where we are with climate change now to where we were right before the Paris Agreement negotiations, which many of you know was the other very serious run by Palau and Marshall Islands at that point to request an advisory opinion related to climate change. That ultimately did not go very far. Why, in my personal view, and I was at the State Department at the time, so this is very much my own personal view, is that their political appetite, the political will was all focused on Paris. It was a moment for the international community to come together and come up with a solution by agreement, by negotiation. And there was a real sense in the room, if you will, that states did not want to diverge from that exercise to a conversation about the legal parameters under general principles of international law related to something as complex as climate change. Here we are now, post-Paris, post-COPs, we haven't gone fast enough or far enough on climate change to save us. And we're in a very different place. And I think it goes to my point about desirability can change over the course. And the other thing I hear a lot, and embedded in your question, Laurence, is there a risk of fragmentation because you have these pending requests? And in my view, I don't think so. I see Nilüfer also there, who's also on the Committee of Legal Experts representing COSIS. We very much formed the legal experts on the ITLO side, coordinating with the Vanuatu Lead Council on the ICJ side, because there is an opportunity for coordination and coherence, not, I would say, fragmentation. So from my perspective, this is very positive. This is states signaling in 3 different fora that the lexicon of international law is relevant, it can be powerful, and it can be synergistic in taking the negotiations where they haven't been able to go alone. So from my perspective, as you can tell, and thank you for the softball, it's very positive on the advisory opinion side.
Well, let's hope the courts are up to the challenge, because there's the ghost of nuclear tests, which is still there. Anyone else got a question?
Thank you very much for your inspiring presentation. I would like to focus on one of the details.
Good. The devil or the detail?
Yes, because I believe one of the details is precisely whether adjudicators are playing their role in an appropriate manner or not. Because this is crucial for the attitude of states. You mentioned many examples, and I would like to keep one, which is Malaysia-Singapore. Because if the court falls short of settling the entire dispute, then there is a problem. And this is just but one example. There are many. So my question is, what is the impact of the adjudicative bodies in their practice for the attitude of states with regard to adjudication?
It's a very, very good point. You're absolutely right. It's a detailed point, and it's also a double point, I suppose. It is very much, in my view, that dynamic, the say, responsible execution of function, underpins the legitimacy aspect of it. And I don't know if you think it relates to efficacy or desirability, but to me, core is legitimacy. And luckily, we're not going to necessarily measure legitimacy based on the losing party, if you will. It is something rather that is a consensus, if you will, of states, a consensus of the international community of lawyers, of practitioners. Where is there overreach? There's almost a self-discipline, or there should be, even without formal res judicata, a self-discipline among our institutions, whether they're private individuals sitting in international arbitration, or judges on the Court of Justice, or judges in ITLOS, about caring for the system by being quite rigorous about state consent and jurisdiction. And we all know every time there's a decision that seems to push the envelope, there is impact on the system. There is a negative impact on the system, and we get to this, we feed the fire of recalcitrant states, in my view. I think the bluefish tuna, that's a decision, we've probably all read it, and there's a declination of jurisdiction in that case. But there's that amazing paragraph in the case as well, as saying we don't have jurisdiction, but I believe the language is in egregious situations of impact. We may have the potential of jurisdiction over good faith violations, relying on a good faith clause and a good faith articulation. A lot of, I'd say, commentary focused on where does that take us in terms of us as practitioners, decision makers, in terms of state consent. Is there a reason to be concerned? But we saw what that engendered. There was a very robust reaction, robust conversation. And I think of that as all a process of self-discipline to maintain the resilience of the system, to be true to a bedrock principle of state consent. So to me, I think that's a detail, it's a devil, but we know how to deal with it. And it's really this community that I think does that so well. Thank you.
I think we're going to have to get Catherine back tomorrow evening. Is there any safe way of proceeding? Any further questions before we... Yes, back there.
Thank you very much for this fantastic presentation. I'd like to pick up on your point of the background of the crisis, and I'd like to ask a question about the institutions, the judicial bodies. So in the background of this crisis, how do you say these institutions, judicial institutions, adapt to this background? And do you consider that the fact that do you think these institutions have adopted some certain measures to entertain the client in the market, or to adapt to the time of the crisis? Thank you.
Thank you very much. So if I understand the question, and tell me if I'm getting it right, how do institutions, courts and tribunals, deal with the underlying context if they have a sliver of it as a matter of their own competence and jurisdiction, both from a substance and a timing perspective? Is that right? Yeah, okay. I'll take the timing perspective because I think the ICJ is actually a very good example of this. If we see the evolution of the speed with which the ICJ is responding, especially in its provisional measures orders, I think that there's a very good and strong case to be made of responsiveness in the context of crises where, of course, time is of the essence, where you have, violations of human rights, where you literally have the rights of people, you have the lives of people at stake. And you've seen the ICJ evolve from a court that frankly did not move with a great deal of alacrity, shall we say 20 years ago, 15 years ago, to a court that is routinely getting provisional measures decisions out within a matter of weeks, as it should. And so I think that there is an evolution of how can these courts be effective, and in the context, again, here of crises, effective with on a time scale that is actually useful for diffusing situations and promoting peace. So that's the timing. And then on the underlying context, the Qatar case was very, very interesting in that respect because there was so much in that. There was humanitarian law, cyber conflict, unilateral economic coercive measures. There were all of these issues that touched different aspects of international law, but the prism through which the court viewed this crisis, the Gulf crisis, was racial discrimination. And so the court was considering facts and, frankly, other areas of law, of international legal schemes that were way beyond racial discrimination, but at the same time, its prism, its basis for jurisdiction, obviously, in the dispute, was racial discrimination. So it was very much a conversation about what is within scope, what is not within scope about the larger crisis. And that's what led to the preliminary objection, which found that ostensibly nationality-based measures are not within scope. And so that's the kind of competence I think that courts and tribunals have to deal with complicated facts that touch different areas of law, but at the same time stay true to their jurisdictional mandate, their sense of what is the right scope of jurisdiction. So ICJ is not isolated in that regard. I think that there's a lot of rigor around that. So from my perspective, just because the crisis, a global crisis, involves lots of different fact patterns, touches a lot of different areas of substantive law, to me doesn't really impact the legitimacy, the efficacy of the adjudicative exercise itself.
Right. Well, I'm afraid we're going to have to bring this masterclass on how to answer questions directly and comprehensively to an end. So that's the bad news. We're up against the clock. But the good news is that there's a drink waiting for you upstairs. But before we do that, can we thank, please, Catherine again.